Get to grips with grown-up topics. Thought-provoking and business-focused articles on management theory, law, Occupy, political Warner Brothers cartoons, and more. Written and narrated by Chirag Patel. What is English law, and who chooses its shape? Unlike most modern legal systems, British law had no real founding document, putting it in a select group of half a dozen or so nations, including Saudi Arabia and Israel. Whereas the vast majority of countries use constitutions drawn up either during or after the Enlightenment, including firm provisions on a series of rights and responsibilities of citizens, and increasingly converging into a globally agreed model constitution, the British system originates with a series of legal decisions by select groups within the country and added to over time. This has several advantages as well as a significant disadvantage. The principal advantage is flexibility. For example, in the American courts, arguments are commonly made based on what the founding fathers, removed hundreds of years in history and an inconceivable distance technologically, intended, even though it is extremely unlikely that they would have foreseen a world with modern communications and transportation, or understood any of the potential effects of these shifts on society. As a result, there are many debates that argue about the interpretation of men long dead instead of the situation at hand. On the other end of the scale are countries with constitutions that are statements of ideal rather than pragmatic considerations of the nation, such as South Africa, which guarantees socio-economic rights like housing, despite having vast proportions of the population living in poverty. The South African Constitution is liberal, free, and modern, existing in a country where none of these attributes can be said to be commonly shared amongst the population. As a result, the Constitution is constantly in the process of adaptive change in society as it comes closer and closer to realization. The British legal system does not suffer from this temporal flaw, since almost all of its law is precedential. This makes it much easier for British law to adapt to changing situations, but also makes it vulnerable to large-scale decisions. If the Prime Minister tomorrow decided to use the party whip to force everyone to wear green hats on Wednesdays, or kill everyone wearing any other hat, there has been historically no protection for the population. This has changed with integration into the EU project, meaning that certain laws have had to be included within British law. Moreover, it is also increasingly integrated into a web of international law, partly as a result of Britain's history and foreign policy. And so large-scale change that is against the international norm is relatively unlikely, and changes towards international norms are almost certain to be increasingly common in future. History. Where does the English legal system come from? The English legal system essentially originates from 4 documents, each of which established a specific foundational rule for the nation. The first of these is the Magna Carta 1215, or Great Charter. The Magna Carta established a series of rights for private citizens, specifically members of the aristocracy, that were separate and protected from the powers of the king. Although challenges to the monarch's authority reduced in later versions, it established the precedent that land could be owned by an entity other than the king himself.
Sample complete. Ready to continue?